Stuhldreher is my best effort. Did I get it?
Stuhldreher, Your Honor.
Stuhldreher.
Yes.
Okay, I didn't get it.
Close.
Whenever you're ready.
May it please the court. My name is Peter Stuhldreher, and I represent the appellant Ace Gathering. This case is about the Department of Transportation's jurisdiction under the Motor Carrier Act to regulate drivers like the plaintiffs who drove large tanker trucks filled with dangerous crude oil that was moving in interstate commerce. The plaintiffs' claims in this case are for overtime under the Fair Labor Standards Act, but employees who are subject to the Motor Carrier Act are exempt from the FLSA. The Supreme Court has recognized that the MCA exemption is unique because the safety concerns implicated are what Congress gave primary importance, even to the corresponding exclusion of overtime pay under the FLSA. Likewise, in the Carley case, this court said that the purpose of the MCA exemption is primarily to ensure that operators of vehicles affecting highway safety are regulated by an entity with a greater understanding of the particular safety concerns, which is the DOT.
You could slow down a little more, just eye contact with us, you got it.
In this case, the only element of the MCA exemption in dispute is the interstate commerce element.
Yeah.
Based on the undisputed facts, the Motor Carrier Act's interstate commerce element is met for two independent reasons. First, the crude oil plaintiffs transported continuously moved in the flow of interstate commerce from the time the plaintiffs picked it up at the oil field until ACE's customers undisputedly transported some of it to refineries outside of Texas. Second, each of the plaintiffs, like all of ACE's crude oil drivers, reasonably expected that they may be assigned some of the interstate routes that ACE's drivers undisputedly drove. For each of those independent reasons, summary judgment should be rendered in ACE's favor.
I mean, the phrase interstate commerce constitutionally and statutorily has befuddled full understanding. And now in this particular sub-area, we've got a multitude of possible tests. Don't agree if I'm wrong. Continuous flow, affects interstate commerce, reasonable expectation, fixed intent, and there's another one I can't even remember. Do those apply in different circumstances, or would you say there's one obvious and overarching test that applies to a situation like this?
I think those tests apply in different circumstances. So, and several of them apply here. First is the continuous flow of interstate commerce. If the goods are moving continuously in the flow of interstate commerce, that's enough under this court's precedent that has repeatedly held that the actual transport of goods across state lines is part of interstate commerce, but also the intrastate transport of goods in the flow of interstate commerce. And the court just held that last month in the Ash versus Flowers Foods case.
Yes, my ignorance is, why wouldn't that swallow every other test? I mean, it is, I'm drawing from constitutional thought, but almost every product is in the flow of interstate commerce.
Under the MCA exemption, if the products come to a stop for warehousing or other storage,
We switch to a different test.
we switch to the fixed and persisting intent test. That's not in the undisputed factual record here, so we don't have to go there. But that is when you get to the fixed and persisting intent test, is if there's a stoppage for warehousing or other storage.
Why was Judge Rosenthal ruled originally against you? Did you give her new authority, or is it's unclear? When your motion to reconsider, you just said, no, it's the continual flow test, and that's it.
So at every stage, both the motion for summary judgment stage and the motion for reconsideration stage, we argued the continuous flow of interstate commerce applies because the goods here continuously flow without a stoppage for warehousing, so you don't have to look at the fixed and persisting intent. We also alternatively argued if you do apply the fixed and persisting intent, because the facts of this case are virtually indistinguishable from the facts in Siller and now in the Ash versus Flowers Foods case that this court just decided last month, with the exception of the flow being reversed and there being no warehousing, that even if the court were to apply.
Correct me if I'm wrong, cases like Siller and Flowers, there the employer is bringing them in, I think. Then you've got the warehouse, the storage facility. No one's arguing that you aren't arguing your employer does anything out of state, and you don't then ship things out of state. Everything you do begins and ends in Texas. Is that fair?
That is fair.
So it is a little more difficult than, say, Flowers, where everyone knows the baked items are coming across the state line.
Well, I think what the court looked at in Flowers was the intent of the interstate shipper. And in looking at the intent of the interstate shipper, it said that the interstate shipper knows it's shipping those goods to a warehouse in Louisiana so that the baked goods can then be shipped onto the customers.
The interstate shipper is you, correct?
No, we don't ship the crude oil across state lines. We're not the interstate shipper. The interstate
Starting
shippers are
in
customers.
Texas, then it goes to the injection point, your job's over, it goes to the port, and then somebody else, a customer of yours, takes it out of Texas.
Well,
Is that too simplified?
I think it may be missing just the most important point, which is what
Okay.
happens before any of that happens. And so before any of that happens, ACE's customers specifically contract with ACE to provide a specific type of crude oil, to provide it in a specific amount, in a specific time frame, and to a specific pipeline terminal. So it's not the case that ACE is just going out and picking up whatever crude oil it wants to bring it to whatever pipeline it wants to, in the hopes to sell it. It is doing that because it's contractually obligated to go out and collect that crude oil and deliver it to the pipeline because of ACE's customers' undisputed interstate intent, to take the crude oil from the end of the pipeline and ship it to refineries to be refined outside the state of Texas. So that's why this case is very much, if you're going to apply the fixed and persisting intent, that's why this is very much like the Ash and Siller case. There's really no meaningful difference between the interstate shippers in Ash and Siller engaging and prearranging for an independent distributor to perform the last piece of the interstate movement.
ACE argues that most of the factors under that fixed and persisting interest test, ACE says most of those factors are just irrelevant here because the crude oil here wasn't warehoused. And what do you say?
I think that's correct. I think the fixed and persisting intent test was specifically designed to determine the effect of warehousing on the interstate flow of goods in commerce. In other words, when the goods come to a stop for warehousing or storage, do either of those parts of the transportation, either on the front end or the back end, become a separate piece of transportation, or is it all in the continuous flow? And in this case, because there is no warehousing or storage of the crude oil, most of those factors don't really make sense given the factual circumstances we have. And just to go back to what you raised, Judge Higginson, ACE's customers contract with ACE and require them to go pick up certain oil. That's the only reason the drivers, the plaintiffs, go out to the oil field to pick up the crude oil.
It's one step removed. Locating who's the shipper here, if we were to even apply the fixed intent. Frankly, I was a little confused as to who would be appellant here. Just to step back and explain some of my questions. But in as much as it's a certified question, the residual thing that the district court ruled was against you, which I take it is why you're appellant. I'm just a little curious.
That's correct. The district court ruled against us or issued rulings that denied summary judgment on really two tests. So we have the continuous flow test, which we argued that both we meet the continuous flow test, but also we meet the fixed and persisting intent test to the extent the court were to apply it. Our position is it doesn't apply.
Yes.
Then there's a separate way of proving interstate commerce under the MCA exemption, which is the reasonable expectation analysis. In other words, did these plaintiffs reasonably expect that they could be called on to drive interstate routes? And
That's a valid test too.
it is a valid test, yes. It's a second separate.
You litigate this a lot more. What happens when the all valid tests come out differently? Let's imagine I put aside Morris. I didn't think Morris existed, so I was convinced that the drivers here actually might not expect to go outside of Texas. And I think the fixed intent test doesn't really apply. It's a different shipper. I'm a little confused by that. But continuous flow, it looks like you're pretty much in the heartland there. That's about where I am. Is that a wrong way to look at this? And then how do you decide which test is the primary test?
Well, I think they're mutually independent tests, and if we satisfy either one,
Okay.
then the MCA exemption applies to these.
You contend you win them all.
I do, yes, Your Honor. That's been our contention all along.
And you prevail on the reasonable expectation because of Morris largely. Is that fair to say?
Well, we
Percentage of people.
Yes. So if you look at the percentage, I guess the bigger picture is the facts as to all of the reasonable expectation factors, and there are 8 of them that have been articulated by this court in the Olivas case. Those facts are all undisputed. They, in our view, they all weigh in our favor. The district court certified question raised an issue with one of those, the indiscriminate assignment portion of the reasonable expectation test. And specifically, the district court's third certified question focused on the impact of what he called a volunteer-based interstate driving system. So in response to that certified question, the Fifth Circuit's instructed in Olibas that no one factor is dispositive of the reasonable expectation analysis. So even if this court were to find that ACE had a volunteer-based system for assigning interstate routes, and such a system weighed against a reasonable expectation finding, that one factor alone cannot be dispositive of the analysis in this case. But also, the undisputed facts in this case shows that ACE did not have a purely volunteer-based system for assigning its interstate routes. Instead, if there were not sufficient volunteers for any interstate routes, ACE would indiscriminately assign that interstate route to one of its drivers. And so because no driver could prospectively know whether there would always be sufficient volunteers, this confirms that, as the plaintiffs themselves testified under oath, ACE's drivers have a reasonable expectation that they could be assigned to drive across state lines at any time if there were not enough volunteers. And frankly, to reach a different result from a legal perspective, this court would have to disregard significant Fifth Circuit precedent. It would have to disregard not only Olibas, which says that any one of those factors cannot be dispositive, it would also have to overrule the Fifth Circuit's decisions in Songer, Allen, Amaya, and Wright-Korshowitz that each found that the reasonable expectation analysis is not an employee-by-employee analysis, but instead is a class-wide analysis.
So why can't this entire problem be fixed with a subclass?
Well, the problem with applying a subclass in this case, Your Honor, is that each of those cases, Songer, Allen, Amaya, and Wright-Korshowitz, have said that you can't form district-by-district subclasses like the plaintiffs have argued for here, that you look at the expectation of the class of ACE's drivers as a whole.
The whole reason we have classes is so that we can define the classes differently. And what's you see by 26% or 27% of the total drivers have had an interstate route. What is the percentage for folks who haul from the South Terminal?
I don't recall the percentage off the top of my head. It is lower.
Really small.
I'm sorry?
It's vanishingly small, right?
It is small.
So why couldn't you just have a subclass of South Terminal haulers?
Well,
Or why
because
couldn't you have a subclass of haulers who had never driven an interstate route, or a subclass of haulers who would resign if ever asked to drive an interstate route? We could do this all day, but I mean, if the legal standard requires a class-wide rule, and this is obviously, as you and Judge Higginson have been discussing for the better part of your argument, we have, I don't know how many standards and how many different tests and how many different factors. It seems like an area of law crying out for a clear, bright line. And this could be easily resolved, I think, by just defining the class in a way that would comport with the interstate commerce requirement.
Well, and so to answer directly your question, I think the Fifth Circuit has drawn that bright line and has answered exactly the question you're asking, Judge Oldham, and it did so in the Allen versus Coil Tubing Services case. In that case, the plaintiffs raised exactly this argument, where they said that the percentages of interstate travel for some districts tell courts nothing about the reasonable expectation of a worker dispatched from other districts. So that's exactly the argument you're raising, Judge Oldham. And in rejecting that argument, the court first noted that Songer looks at the reasonable expectations of the employees as a class, even if in doing so the effect is to apply the MCA exemption to employees who rarely or never engage in interstate commerce. The court then went on and said Songer does not instruct us to subdivide a class of employees by geography, and the facts of this case do not support such an artificial division. And the facts that Allen relied on there were that the districts, just like ACES districts, operated under a single DOT number, were not independent legal entities, borrowed personnel from each other, and solicited and accepted projects outside their geographic areas. So I think the Fifth Circuit's already spoken on the issue of drawing a smaller district-by-district class as far as the reasonable expectation analysis.
Hypothetically, assume that all of the oil that ACE injected into the pipelines ultimately and only reached Texas refineries, okay? Would you concede then that there's no interstate commerce? I'm just trying to understand how far we're supposed to follow this chain of distribution.
Just to make sure I understand your hypothetical, Judge Willett, you're suggesting that instead of some of the oil going out of state, all of it ends up at a Texas-only refinery?
Yeah, if all the oil that ACE, that your client injected, wound up ultimately only within the borders of Texas, would you concede then there's no interstate commerce?
The reason I'm going to say no, Judge Willett, is because there are still ACE drivers who drive across state lines. And so we have a second sort of mutually exclusive piece of the analysis, which is the reasonable expectation analysis. And so I would agree that changing the facts in the way that you just described may impact the continuous flow of crude oil and interstate commerce prong of the interstate analysis under the MCA. It wouldn't change the fact that ACE drivers still, in some circumstances, are assigned to drive into other states to pick up crude oil.
What if they didn't do that? Just keep Judge Willett's hypo exactly the way he had it, but just now the drivers are all based in Texas. They drive from Lubbock to Midland and back and forth, but all within the state of Texas. The injection points are in Texas. The terminals are in Texas. Then no MCA exemption?
I think that's probably right, Judge. I'd have to concede that. If there's no reasonable expectation and no flow of the crude oil and interstate commerce, I think there is no interstate commerce under the MCA.
So I don't mean to put words in your mouth, so just tell me if I'm misunderstanding your contention. It's the two things that make this case an MCA exemption case is that we have drivers who cross state lines, some, and we have terminals that are not in Texas. All the injection points are in Texas, but some of the terminals are not, or even the terminals are also in Texas.
The pipeline terminals relevant to the routes that the plaintiffs drove, I believe, are all in Texas. Yes.
So we have injection points and terminals all in Texas, but the thing that it makes the only fact then that matters is that we have some drivers who drive across state lines before putting into an injection point in Texas.
Yes, yes, that matters, but also the fact that the crude oil in this instance, and I'm sorry if I was supposed to answer a question that was related to Judge Willett's hypothetical, and I'm answering based on the facts of the case.
I'm sorry, I was trying to compliment them, so feel free to answer it however you'd like.
Okay. What makes it interstate commerce for this case is the crude oil undisputedly flows without stoppage from the oil fields in Texas where ACE's drivers pick it up to refineries outside of Texas. Separately from that, there are a number of routes that ACE's drivers drive that do cross state lines, and under the reasonable expectation factors in Olibus, each of the plaintiffs and all of ACE's drivers as a class have a reasonable expectation that at any point they can be assigned those routes.
Yeah,
Just one quick follow-up on so I understand the second point about reasonable expectation and the routes that go outside the state lines, but on the first point, I just want to make sure I understand factually what's going on. The injection points and the terminal points are in Texas, but when you say they're going to refineries in Louisiana and whatever, those are from people who are not related to ACE. Those are third parties that are taking it from a terminal in Texas, putting it on a truck or train car or whatever, and moving it to someone not named ACE is moving it across state lines.
Just to be very clear
On
about
that first point.
To be very clear about my answer, you're right that it is not ACE. However, it is not any party. It is the party that specifically contracted for ACE's gathering services to perform the first leg of that interstate journey from the oil field to the pipeline.
But ACE gets the benefit of the fact that that the customer is then going to take it outside of. So if I come to you and I say, hey, listen, I'm running my oil depot in Austin, but just FYI, I fully intend to put this on a rail car and move it to New Orleans, you get the benefit of the interstate flow. Even though I'm not ACE, right? I'm the third party, I'm the customer. In
the same way the independent distributors in Siller and Ash got the benefit of another party's flow of interstate commerce, yes.
You've saved rebuttal time. We'll hear from Mr. Qualls.
May it please the court, your honors. The court must affirm the district court's denial summary judgment because there are genuine issues of material fact as to whether defendant is entitled to an exemption under the Motor Carrier Act preventing summary judgment. Furthermore, the court should reject defendant's invitation to essentially broaden the interpretation and application of the Motor Carrier Act exemption. The genuine issues of material facts exist as to whether ACE's shipment of crude oil was transportation of goods in the flow of interstate commerce, and whether plaintiffs could have reasonably expected to engage in interstate commerce consistent with their job duties. It is our position that ACE's shipment of crude oil was not in the flow of interstate commerce. It is undisputed that ACE purchased the crude oil from third-party producers within the state of Texas.
But let me just, the plaintiff group is a group of drivers of 18-wheeler trucks.
Yes, Your Honor.
Product is oil.
Yes, Your Honor.
So we're asking, are they subject to the safety regulations of the Department of Treasury because they are motor carriers? Just, it would seem just atmospherically, they're the quintessential motor carrier, wrong? In other words, they're driving trucks that contain a product that's going all over the world.
Yes, Your Honor. What we would say is we're not disputing that they otherwise meet the elements that are necessary for the Motor Carrier Act exemption to apply. But what is at dispute is the interstate commerce element of it. And to my knowledge, there's been no case presented that states that petroleum or crude oil in and of itself is a good that automatically would have the Motor Carrier Act exemption test apply. There still
Can you
has
think of any circuit that has not applied the Motor Carrier Act exemption to 18-wheeler truck drivers as to a product that is ultimately ending up, after their segment's over, out of state? Can you think of any court that has said, no, you're not subject to DOT safety regulations?
I can't think of a specific case, Your Honor, where that happened, but I think part of the reason for that is some of these cases that the parties have discussed in their briefing that deal with the transportation of petroleum or crude oil is you see that the shipper has an interest and control over that product throughout the journey of the crude oil and petroleum. And that's not the case here as it is in some other cases, such as in the Galbraith case. Gulf Oil still maintained interest and control over the crude oil through its journey, and the court discussed that the pipeline that was used, Gulf Oil had, I believe it was a 14% ownership interest.
You mean interest and control that extends to the next state?
Yes, Your Honor.
What about, I mean, we do have published authority, and I'll mention the two that seem most salient in the briefings. Songer, and then the much older case, Merchants, Merchant Fast? They both are pretty explicit that even if your segment's just the intrastate segment, and the word they use, if it ultimately ends up in another state, that's within the continual flow. Am I mischaracterizing that test in those cases?
I don't think it's mischaracterizing the test. I think that from our position, the test that matters when there is an interstate-only transport is the essential character of the shipment, which is the fixed and persisting intent of the shipper. And so
cases like Flowers would be the case law you would point to.
Yes, Your Honor.
And you're saying ACE couldn't have that intent because its intent only starts and ends in Texas? Is that the logic? It's not a warehouse case.
That is the logic, Your Honor. And though it's not a warehouse case, questions of movement, cessation of movement, and interruption of movement are all factual determinations. Mm-hmm. And, in this case, when ACE deposits the crude oil in the injection points in the pipeline, going back to the fixed and persisting intent of the shipper, their total interest and control ends there. Unlike some cases, such as Flowers or Siller, the shipper still had an interest in what happened to that product once it changed hands. And that's just not the case here. ACE's customers, they may hold that oil for a period of time, they may send it out somewhere else immediately. None of that matters to ACE. Unlike in Flowers or Sillers, though ACE has title and control to the crude oil, it's not really their product. They're simply buying the product to then sell and change and give that title to their customers. Whereas in cases like Flowers or Siller, those entities cared what the next step would be because that's how they make their money, is it ultimately ends up on the market. Whereas ACE here, they earn the revenue as soon as they sell the oil and they put it into the injection point. And I think that's part of what distinguishes this case from some of the other cases in the Fifth Circuit that have been cited. The other element, as the appellant has pointed out, is also the reasonable expectation of plaintiffs to engage in interstate commerce. And this is this is more than a mere possibility. This is a test of a reasonable expectation. And while no factor is dispositive on what leads to a reasonable expectation, what you will find with a lot of the cases that did find there was a reasonable expectation is you will find that the factor of were assignments indiscriminately assigned it's almost always present. One case that comes to mind is the Rose v. Chemical Line case in the Western District of Texas. In that case, these dealt with individuals who were shipping lime across borders, and the particular plaintiffs in general in that case showed that even though there was evidence that the employer had told all of them they could expect to be involved in interstate commerce, that there was a question of whether those assignments truly could have been assigned indiscriminately. And I think that applies here as well. As the court is aware, though we look often at a company-wide basis on the percentage of what trips are interstate, I think you can look under the factor of were these trips applied indiscriminately by looking at the reality of how many of these trips were coming from the terminal where our plaintiffs were located. And it was less than 1%. And that makes sense logically and with common sense. If you have terminals on the eastern and western sides of Texas, and you're needing to make trips across the border, logistically you would choose your drivers that are closer to make that trip. And I think the evidence bears that out. And in Rose v. Chemical Lime, the court also had made notice that the drivers were hours away from an interstate border. And I think that applies here as well. And it's undisputed that the drivers volunteered for these assignments. I think there is a dispute on whether or not they were truly assigned indiscriminately after it was done on a volunteer basis.
What do you make of Ace's argument that because the oil here isn't warehoused, there's no warehousing of the crude oil, that your argument that the fixed and persisting intent factors, they're just out of place?
I'm sorry, Your Honor, I didn't catch the end of your question.
They say that the fixed and persisting intent factors are out of place, irrelevant, because the crude oil here just wasn't warehoused anywhere. And I just wondered what your take was on it. And is there really any case where the court has applied that test, the fixed and persisting intent test? Is there any case where a court's applied it that doesn't involve a storage facility or a warehouse or any other allegation that the product that was being shipped came to rest?
I'm not aware that there is a case that is exactly the same as this case, and I don't know if it's just not an issue that's been litigated, but it's our position that we believe the fixed and persisting intent based on the case law is the primary test that applies in these type of cases where you have a solely intrastate movement of products before there is a change of title, interest, or control. The court characterized it as...
Has that test ever been applied where the product didn't come to rest, where it wasn't in a warehouse or some other storage facility? Can you think of any?
I'm not aware, Your Honor. I've not seen a case where... I can't recall that I saw a case where that occurred, but I'm not sure that in that case that a different test would still apply. Appellate certainly makes a distinction based on these scenarios, but appellant also, their supplemental authority that they provided, NIL, still use the fixed and persisting intent. And granted, I recognize that's still a case of where it's being warehoused, but I think that shows that that is still a commonly used test when we're trying to determine whether an object is, a product is still within the stream of interstate commerce. One thing I also wanted to touch on is the standard of review here. This is de novo, but this is also a summary judgment motion.
You heard my confusion about that a little, because in the end, Judge Rosenthal simply certified questions to us. She hasn't put her finger on the scale. She's asking us to answer these questions. So
Yes, Your
if you
Honor.
were to prevail, I don't think we'd be the summary judgment. We wouldn't affirm summary judgment, I don't think, but maybe you do. We would answer the questions. And
I see what you're saying, Your Honor. I think that those questions would still go to how those questions would still go to whether or not summary judgment is applicable in this case.
right, but you were saying maybe there's a deference here, and I'm not sure I see the deference. She's asking us a legal question. Or
Sure.
three legal questions.
Sure. I guess the point I was trying to make is when it's a summary judgment motion, there are genuine disputes of material fact when a reasonable juror can come to a verdict for the non-moving party. And I believe it was the 1992 ICC policy statement that both parties briefed. There was a dissent by one of the commissioners where the commissioner recognized that reasonable people can come to different conclusions in these cases from the application of the law. And I think that's what happened here is the district judge came to a reasonable conclusion based on the record before her that a jury could find a verdict in favor of the appellees here, and that because of that, summary judgment could not be granted, and that this ultimately should be something that is decided at trial rather than here at the summary judgment stage.
Do we need to do anything else? Anything more than just say the ultimate destination of this crude oil was out of state and is therefore interstate commerce? Why isn't that dispositive?
I think it's not dispositive because some courts have recognized that it's more than just a mere intersection with interstate commerce. I think that's a step too far because if it's just where the product stops, I'm not sure what the limiting factor would be. I think almost anything would be interstate commerce if that were to be the test. And so I think that's why courts in this circuit, but also courts in other circuits, will look at the intent of the shipper at the time of that interstate shipment to determine the of whether or not it's in the flow of interstate commerce. One of the circuit court cases that we decided was the Collins case in the Seventh Circuit, where it described a situation that if a product, it was alcohol in that case, if it were to change title while being warehoused, then it would not be interstate, regardless of what happened to it afterwards. And I don't think the cases in the Fifth Circuit use such definitive language, but I think you see in their analysis, they talk about the control, the interest that the shipper has in these cases.
Along the lines of Judge Will's question here, and I don't pretend to think the interstate commerce definition is easy, but when you say the Fifth Circuit doesn't limit it, we may also have this focus on title and interest. This is from that case I'd mentioned earlier, Merchants Fast Motor Lines. It is elemental that a carrier is engaged in interstate commerce when transporting goods ultimately bound for destinations beyond Texas, even though the route of the particular carrier is wholly within one state. That is a problem unless that test is superseded. In other words, it's elemental that you're involved in interstate commerce if the goods are ultimately bound for a destination beyond Texas, even though the route of the carrier, the particular carrier, is wholly within the state. That sounds like regardless of who has interest or title.
What I would say, Your Honor, is that interest and title, it's not necessarily a test in and of itself. It's one of the factors that a court will look at. And I think there are certainly cases that show that the shipper doesn't necessarily have to know the ultimate final destination of the product in order for interstate commerce to be found. But there still has to be, I think, an intent at the time of deciding to ship this, that this will be involved in interstate commerce. I think a lot of these cases, such as the flowers case, you often see that the product begins its journey across the interstate line, and that is often how we see that these parties intend for it to continue. But what's different about this case is Ace arguably did not care where the crude oil ended up. Its customers very well could have just had it refined in Texas, and they would be none the wiser. There's no joint allocation of benefits that you see, or ownership that you see in these other cases. And I concede that when talking about interstate commerce, it certainly can be fuzzy, but I think that the cases, I don't think that the court needs to make new law here. I think that the law that exists supports the appellee's position, and I think that the district judge could have potentially came to a different conclusion, but she didn't, and under the summary judgment standard, I think that's fine and that it should be upheld for that reason, because the test is whether a reasonable jury could have found a verdict in favor of the non-moving party.
Thank you, counsel. We appreciate it. Rebuttal? There's 3 minutes.
May it please the court. Your Honors, just a couple quick points, as I know I've got limited time. First of all, Judge Higginson, I think you just raised the issue of the Merchants Fast Motor Lines language, and that it would be problematic for the plaintiff's case if it hasn't been superseded. I just wanted to answer that not only has it not been superseded, the same type of language, the same conclusion has been espoused repeatedly at the Fifth Circuit, including cases like Allen versus Coiled Tubing Services, and including just last month in Ash versus Flowers Foods. Additionally, the Supreme Court in United States versus Capital Transit has come to the same conclusion.
Did
With-
Capital Transit predate?
Yes, it predated those cases, yes. It was a 1949 case from the Supreme Court that found that intrastate transportation that was still part of a continuous stream of interstate transportation was nevertheless covered under the MCA for interstate commerce purposes. With regard to the argument that ACE's interests only begin and end in Texas, essentially meaning that ACE buys, sells, and transports the oil only in Texas, the issue with drawing a distinction with that here is that that would have to go against, and this court would have to necessarily overrule Siller and Ash. And I think part of what happens in the plaintiff's argument is a conflating of who is the shipper. And the shipper under the Fifth Circuit case law has always been the entity that transports the goods across state lines. That's not ACE in this case, it's its customers. And its customers clearly have the same intent that the interstate shippers in Ash and Siller had, and the independent distributors who are also found covered by the MCA exemption in Ash and Siller also bought, sold, and transported the goods all within one state. Separately, the plaintiffs also reasonably expected that they could be assigned to drive any of the routes ACE drivers drove, including any of the numerous routes in which ACE drivers actually crossed state lines. They were not assigned specific routes. They were given different routes every day by dispatch, and they all knew that if there was ever a situation where there weren't enough volunteers for an interstate route, they could be called on to drive it, and that's enough under this court's precedent in Olivas.
You're not putting any weight on the offer letters here. I didn't see much legal significance. Maybe you want to.
Well-
a lawyer can't just say, hey, this is what to expect, and then that governs the MCA exemption.
No, I think there have to be more facts, and there are in this case beyond just the offer letters, but I do think the offer letters and the plaintiff's testimony that they at all times had a reasonable expectation is relevant, and even Songer looked at the testimony of the plaintiffs in that case. And so ultimately, I think the bottom line, Your Honors, for this one is that any result other than this court's reversing the district court and rendering summary judgment in ACE's favor would be out of step with Supreme Court precedent, this court's precedent, applicable regulations and guidance from both the DOL and the DOT, and even precedent from several other circuits. Thank you for your time today, and thank you for the opportunity to present oral argument on this case.
Thank you both. We appreciate it, and we'll call the last few.